Hi, welcome everyone to our online year-end estate and financial planning workshop. I am so glad that we're able to do this, and I know that you are all joining us virtually, and we appreciate you doing so. We have a lot of great information that is coming your way, so feel free to get a pen, a paper, some notes. We definitely encourage you to have some questions that we will have at the end, and allow you time to ask our participants. I know that during this time of year, a lot of us are wondering, what the next year is going to look like, and especially this year being so unprecedented and so many things coming at us from different directions. But something like financial planning is so important that we get our heads around. And I know that sometimes we have a lot of different questions. We might not know where to begin. As caregivers, it's not only what affects us, but what is affecting the person that we care for, as well as the family that we have, whether you're living with them or maybe outside of your immediate circle. So I am really thrilled to be able to put this event together with two wonderful presenters. And I want to introduce them to you because they're going to be doing this presentation together. And it's really an honor. I've presented with a couple of them, actually both of them in the past, a couple of times, and it's been great. So I want to, at this time, introduce Kimberly McGee. And what I'll do is I'll introduce both of them since they'll both be speaking together. Again, feel free to jot down any notes as it relates to your the speakers that you'll be hearing. Miss Kimberly McGee, obtained her Juris Doctorate at California Western School of Law. She graduated magna cum laude, and her BA at the University of California, San Diego. She is the principal attorney at Black & McGee, a professional law corporation. She is a certified elder law attorney by the National Elder Law Foundation and a certified specialist in estate planning, trust and probate law by the State Bar of California of legal specialization. She focuses her practices in the area of estate planning, trust, litigation, elder law, probate, conservatorships, long-term care planning, asset protection, and retirement planning. Ms. McGee is also a member of the State Bars of California and Nevada. She's a member of the California Lawyers Association, Trust and Estates Executive Committee, past president of the Southern California National Academy of Elder Law Attorneys, vice chair of the North County Bar Association California Conference of Delegates, and board member of the Southern Caregiver Resource Center, which is our organization. So proud to have her on our board. She's also a frequent lecturer at local bar associations as well as National Academy of Elder Law Attorneys, and can be seen all over the community talking about dementia and elder care. Now, before I go to our next speaker, I do want to say that if you haven't connected to our services, at Southern Caregiver Resource Center, we focus 100% on the family caregiver. And many of you might be thinking, oh, I didn't even know I was a family caregiver. I just care for my mom or my dad or my relative. And it's really important that if you need help, that you reach out to us, that you connect with our services. Our staff is professionally trained. They know and understand the challenges of being a caregiver. So I want to make sure that you connect to our website and our services. So let me give you that so you can jot it down. And of course, we will share that information at the end as well. But we are Southern Caregiver Resource Center. We focus all over San Diego County. Our services are delivered English and Spanish right now, online and virtually, like we are doing this workshop. Our phone number is 858-268-4432. And we also, our website is www.scrc.care. We want you to connect in case you are in need of assistance caring for your loved ones. And now I also want to introduce Daniel Guillen. And Daniel is also someone that I've presented with, and he's very dynamic and has a lot of great information. He's an accomplished visionary executive offering 24 years of progressive experience as a San Diego family wealth and business advisor. He's adept at managing operations, financial administration, and any plans that meet current and future needs. He frequently lectures on investment and personal finance topics for various organizations around the community, and recently taught at San Diego Christian College and Southwestern College, where he's also a member of the board of directors for their foundation. Daniel is an accredited investment fiduciary and has earned a financial planning certificate from the College for Financial Planning, Inc. in Inglewood, Colorado. So as you can see, we have our experts who are going to be sharing with us and with you the ins and outs of planning for your financial future, for your family's financial future. And at this point, I'd like to welcome them and hear what they have to say.
Thank you so much for that introduction.
Yes, thank you, Martha.
I am Kim McGee.
And I'm Daniel Guillen.
And we hope you're going to enjoy today's presentation.
Right. So, from our old friend Ben, nothing in this world can be certain except death and taxes. So, can you answer these questions? What happens to my assets when I pass? Am I leaving a big mess for my family to clean up? And are they protected? How do I protect my assets from rapidly increasing healthcare and long-term care costs? And can I pass my assets without court administration? And how much does that cost?
So hopefully we answer those questions for you today. And so regardless of your personal situation, it's very important that everything we talk about today applies to you. Everything we say has some impact on your life. It is important to have an estate plan. Everyone should, whether you're married, whether you're single, whether you have children or no, whether you're wealthy or not, and whether you're working or retired. A lot of people tend to wait to create an estate plan till they're retired. Well, that's great, except what happened when you turned 18? That was the day nobody could speak for you. That was actually the day you needed to start thinking about your estate plan. We're going to walk through why that's important and how that applies to you.
Right. So the benefits of a proper estate plan. Number one, it provides control. So you get to be in control of your assets, of your decisions. You get to document your intentions, so there's no guessing, when something happens to you. You're able to transfer your assets a lot more clearly and properly. It simplifies the complexities of the estate planning process because it can be a little complex sometimes. There are some potential tax advantages, and we'll discuss some of those as we walk through this here. And so hopefully it provides you peace of mind.
Yes, and you'll learn from me today that I am a control freak. So the really good point of having an estate plan is so that you can stay in control, right? The benefits while you're living. You get to document your intentions. We're going to talk about how an estate plan is basically a manual, a user's guide for your life while you're living. You can also transfer your assets at your own discretion. I make a joke, and you'll hear this, is that if you don't make a plan, the state of California has one for you. So, you get to decide what your intentions are and whether you want to follow the state of California or another state's rules, or you want to make those decisions. You also want to be the person in charge of who decides who's going to take care of you and make your financial decisions when you no longer can, right? Financial and medical decisions. Who's going to be that person? You, if you plan, get to decide. If you don't plan, a court's going to decide, or your kids will get together and decide which one is the one, or the state could come in, the county could come in. So it's very important that you document it.
So when it comes to pulling the plug, you certainly want to have that documented.
Yes, if you are a pull the plug kind of person, you definitely want to have that document in place.
So benefits after your death. Again, you get to appoint a guardian to care for your minor children. You get to be the one to decide how your assets, which we know the family is going to be fighting over, get to be distributed. You also have the option of donating gifts to charity or other nonprofits, and potentially minimizing some tax issues that might come up. There are ways also to avoid legal complications as well as family disputes, which you were talking about, right? And being able to not just pass on the value of your assets, your liquid assets, but also having a proper way to allow your business to continue to succeed without you.
So in my world, as the elder law attorney, I like people to focus on while they're living, right? Most people tend to focus on estate planning and they think about when you're dead. But the truth is what do you care? You're dead. So let's talk about starting point is what happens when you become incapacitated.
Right.
So what does it really mean? And it's just the mental or physical inability to do something or manage one's affairs. It's like a legal disqualification. You can't do something. Number one, I like to start. In California, you are presumed to have capacity. So that is where we start. It's a probate code 810, you're presumed. Everybody starts there. But as we know, there are things that happen. Strokes happen, traumatic brain injury happens, dementia and other type of cognitive impairment happen. So we have to prepare for them. We can't pretend they're not going to happen. They happen to so many people at times you don't have a clue. I have a very dear friend whose son was in a head-on collision. Traumatic brain injury, 21 years old. I have a client taking care of his mother. The stress of it, 43 years old, had a stroke. It's not an age. It's a plan that we have to protect from, right? And again, I want to stay in control of my own life. So the best ways are to, as early as possible, start with something, a durable power of attorney, and that's for asset management. The reason we need that is, again, who's going to talk to your bank? Who's going to talk to your cell phone carrier? I have a girl, my friend's daughter turned 18, and she called me up and said, my mom wants me to call you. And I said, well, you're 18 now, you need powers of attorney. And she's like, why? I don't have anything. I said, do you have a cell phone bill? Well, yes. Do you have internet access? Well, yes. Do you have a bank account? Yes. Well, if something happens to you and you're still alive and you're in a hospital, your mom can't access them anymore. And it really kind of shocked her. So you think about it, where are you in your life right now? Is there somebody who can access your bank? Is there somebody who could do something when you cannot do it for yourself? You're still alive, but you can't do it for yourself. So it's important. So if you have to write it down, you just can't assume your spouse is going to be able to do it. Assume your parent is going to do it. It has to be in a written document. Otherwise, you've got to go to court. And court, while it's an option, it's not a great one. It's expensive, and the world gets involved in your business. Again, control freak. I don't want the world involved in my business.
Right.
So the control, that's what I like. You get to decide how and when and under what circumstances. It's not a one-size-fits-all document. It's a document that you can create. Well, I don't really want two doctors to have to decide. I don't really want my family to have any input. I don't really want, you get to decide what that is. So it's a document that you control. Yes, there are forms you can buy. It's really important, though, to talk out what your goals would be and speak with an advisor who can help you fit that box, fit your goals into that box. And so when we say that a durable power of attorney for asset management will avoid a conservatorship, that's exactly what I mean. Is a conservatorship is a court proceeding. It is an adversary proceeding that someone you love or the county files against you in order to take away all of your legal rights.
Doesn't seem right to me.
No, it is a very overly expansive procedure just so somebody can access your bank account. What happens in a conservatorship is not only can they access your bank, they get to decide how you spend your money. They get to decide all of your decisions. I make the joke, it's not a joke, but I consider it civil imprisonment. It's just like having your legal rights, your constitutional rights taken away. So it's important that you really focus on, do you want to wait for that to happen? Or do you want to be in control? And we're not even talking about the cost of conservatorship. So, imagine it's expensive.
So appointing someone, really, and taking the time to consider who's going to be in that role, that's pretty important.
It is. because you get to make that decision. And think about it, if you didn't decide, and let's say you've got the two girls, right? You love your daughters dearly, but they don't really get along the best. They're going to fight in court over who's going to make decisions for mom. Why do that to them? Why create that animosity when you could do it for them in advance?
Right.
So, what happens? You become incapacitated and you're in the hospital. What happens? Right? Nobody can speak for you. So an advanced healthcare directive, or, okay, when in doubt, blame a lawyer, right? I say that. The advanced healthcare directive is a document that people consider, think about your living will. That's the same document now in California. It's also the power of attorney for healthcare. Other states are healthcare proxies. You know, I can go on and on with the names, but it's the person that's going to make your medical decisions when you cannot. And it's also a document that's going to define your wishes. So when you think about who's going to be that person, right? An agent who's going to make your choices. Not their choices, your choices. So I have clients who want to appoint their sister, but because of their religious beliefs, they can't do certain medical procedures. I said, is that really the right person to appoint then? No. Is the caregiving daughter the right one at all times, right? I've had the privilege or burden to make the end-of-life decisions twice. It is something that is very difficult to do. You want to appoint the person that can do it. You want to appoint the person that you can talk to about your wishes. I've done it twice. I don't carry guilt. The reason I don't carry guilt is because I made my parents tell me what their choices would be. What do they want? What kind of quality of life do they want? How much or how little medical intervention do they want? Without telling anybody, how are you going to know?
Right.
And how are they going to make the decision? They're going to have to decide for themselves. And they're in crisis. This is an absolute crisis moment. They're not going to have all this, time to sit around and think about it. They're going to get the call at 4:28 in the morning saying, there's a code blue, cardiac arrest, what do you want us to do? You're on a phone. It's 4:30 in the morning. If you haven't had that conversation, what are they going to do?
So someone like that you trust may not necessarily be a family member, right?
Correct. It can be a family member, a close friend, even a professional. There are people that actually do this for a living. Why? I don't know, but they do. And God bless them for doing it. So you can limit to what level they can make these decisions. So let's say there's certain people in your life that will be really good at one side versus another. So you get to create those boundaries. And again, controlling your decisions just makes you feel so much more comfortable in life. Also, you've got the other issues about organ donation, right? That's a pretty large decision for people. And in the spur of the moment, you want to know. Your loved ones are going to want to know what you would want. Because some people really want it to happen, other people really do not. So stay in control of that.
Taxes and estate planning. So proper and proactive planning, which we really obviously prefer, that's why we're here, offer opportunities to mitigate taxes. So during this presentation, we're going to focus on income taxes upon death, capital gains taxes, gifting and or inheritance taxes, and estate taxes. So after you pass, or there's very little that you can do to rectify any mistakes that might have been made, right? So that's why it's very good that we actually take these proactive steps to make sure that this is all squared away before you pass. And so after you pass, there's some income taxes that may be due in the year of your death, right? Some final income tax planning could have happened prior to your death, but any planning that you didn't get to, so now there's going to be income taxes that your heirs are going to have to worry about. Income earned by your estate after your death, but maybe before the assets are distributed. So a tax return, again, will be filed in the year of your death to potentially, get rid of other issues that might be there. So that could also cause the process to take a little bit longer because that has to get taken care of. So a widow or widower has a choice of filing taxes single or jointly in the year of their spouse's death. So depending on what the tax planner might suggest, that could be one way to potentially reduce some of those taxes. But again, proactively planning in advance can help ensure that all of this is squared away before. Capital gains taxes. So depending on how the assets are transferred, capital gains will be calculated on the assets, on the type of assets, and whether or not the assets are gifted and or inherited.
So I'd like to start with capital gains taxes and the fact that when we talk about taxes, as he's doing it for a reason, my eyes glaze over. I don't think anybody likes to talk about taxes, but death and taxes, you can't get away from them, right? So I'd like to think of when somebody's talking about capital gains taxes, think about it really simple. You buy something for $1, you sell it for $1,000, the IRS says you just gained, wait, the lawyer's doing math, $999. So, there's going to be taxes due on your gain, right? That's capital gain. So, in a nutshell. So, gifting is if you give away an asset that you purchased for a small amount and it's now worth a large amount, that when you give it away, that person's going to have to pay taxes. So, we have a good example. And let's say a father purchased $1,000 or 1,000 shares of Apple stock, and it was worth $10,000 when he bought it, right? There it is. We've got our basis. That's the number that it costs to purchase. Then 5 years later, he's like, I don't really need it. I'd like to give it to my daughter. She graduated college. She got married. She had a baby. So he gives her the stock. But when he gives it to her, it's now worth $15,000. So since when he bought it to when he gave it away, $5,000, he's technically gained.
That was like a few months worth of Apple shares, right?
Exactly. So if the daughter later sells the stock, she's going to owe capital gains on that difference because she gets it at the value that dad had it at. I hope that makes sense. And we're going to take questions when this is over, so you can always ask us then. Right. So write it down, don't forget. The idea is if the sales price is more than $10,000, she's going to pay taxes. So hopefully that makes sense. That's the negative of giving a gift of what we call appreciated property.
Instead of
giving the gift of appreciated property when you die.
Right.
So, we always, estate planners tend to make an inappropriate joke saying the best thing you can do is die owning appreciated property because you just got rid of all the taxes. It's an amazing thing. So an inheritance, right? I'm going to leave it to you when I die. You're going to get it. And how that works is, let's say I bought it for $10,000, but now I owned it when I died. And I'm going to give it to my daughter. In my will, hopefully a trust, and we'll talk about that in a minute. But what happens is my dad's original purchase price, that $10,000, disappears. And whatever the value is when he died, that's the new number for calculating your capital gains.
that step up.
It's called the step up, right? You get a step up in basis. So what'll happen is if the daughter decides to sell it at $15,000, right, when she gets it, and it's still worth $15,000, then she pays zero taxes. Let's say she holds on to it for a little bit. Well, and she sells it when it's worth $20,000. Does she have to pay tax from $10,000 to $20,000? Nope, because $10,000 disappeared. So she's going to start at the $15,000. So that's the real benefit of, again, dying with appreciated property.
So not only in this process are we talking about making sure that the daughter actually gets the stock, but here there's a tax advantage to leaving the stock to her when you pass, as opposed to gifting it to her while you're living.
Correct.
Right?
Yep.
So you might think that she gets it sooner and it's better, but here's something that shows that maybe that there could have been a better way.
Yes.
Right?
So getting some advice before we take these major steps in life is always a good idea.
Right. So the gift tax we're talking about, so essentially while you're living, you do have the ability to gift items away. And in this case, let's just say we're gifting cash to our family members. Right now the exemption is $15,000 a year that we can gift to another individual. And it doesn't necessarily have to be a family member. We can gift up to $15,000 to another individual for gift tax purposes. Right? And if we give more than that, there may be some tax implications, but we can gift up to $15,000. And so if we're married, we can give then $30,000 to that one individual. So it's a pretty neat way of being able to give some money to someone without having to worry about tax implications. And then there's the lifetime ability of gifting. That's a pretty high number there, Kim.
It is.
Yeah.
Yeah. So basically, it looks like you can give $11.58 million away before you have to pay tax.
Yeah.
If you have it, I'll take it.
All right, we should be talking. Right? And it typically excludes the charity, nonprofit, or the spouse, right? And we don't have to worry about those issues because there are certain special rules that apply to our charities, which we're going to talk about, and our spouses, right?
And it's important while we're talking about this that we acknowledge we're doing this on December, 2nd, 2020. And the reason why is because these numbers, this $11.58 million, the estate tax, the gift tax, we're going to talk about the estate, it's going to change. It's a very fluid number. It ranges throughout history as 0 to 600 to right now the highest at 11.58. Because it's a fluid number, it's important that when you're making gifts, when you're making decisions, that you talk to somebody first. So I just want to throw that out that these are the numbers today.
Yeah.
January 1st, it could be different. Because
Right.
the one time, let's see, was it December 22nd when it went up to 11 million?
Something like that. Yeah.
So it could happen at the end of the year. We don't know.
We don't know, but why do we worry about that, or why are we concerned about that? Why would we want to discuss proactive planning? Well, because of this number right here. Because if we do end up leaving more, and at this point, more than that number, many of us might not be too concerned about that today, but who knows? That could change tomorrow, right? So the idea is if we think that we might be close to this figure or some figure lower than that, and we're worried about the impact of that on our heirs, then there's some planning that we want to consider, right?
And I want to throw out that because that number's so big, it doesn't really affect as many people as it used to. It went from 1 million to 5 million to 11. It probably will go down. If you're here in California, $1 million is not that large. Your home probably covers most of that. You don't think of being a millionaire, but your home is worth $780,000 already. Give it a couple more years, gosh knows what it's going to be then.
Sure.
So it's really important to kind of think about, keep an eye on these numbers, talk to advisors about these numbers, and then do the proper planning. There are ways that people can do small planning and change major lives.
Absolutely.
We were talking, or on the last slide, about charities. People need to remember that a charity is a great option to avoid taxes and to benefit your community. So those are the two things, you want to start thinking about, even if you feel like you don't have an estate tax and this does not apply to you. If you have real property in California, it probably is going to apply to you.
Yeah. And, we're not talking about this happening today, right? Mm-hmm. This could happen 10, 20 years from now. And so by then, you may very well be in a situation where proper planning would have done you some good. So not to mention the fact that if you're close to that figure, as Kim mentioned, you could always consider your favorite charity, right, to help reduce that figure so that you're not going to be impacted by that large expense that could come to you, right?
Exactly.
Portability, what does that mean?
Oh, I don't know. Again, I'm a long time. No, we're just teasing. So portability is if you're married, right? How do I take the benefit of being married? Right? There's a lot of burdens. Right? Married. We get it. But the IRS has given us a great benefit. And you get to maximize 2 of the estate tax and gift tax. So let's say I can, my spouse and I could die with over $22 million and not have to pay taxes.
It's nice.
Wouldn't that be great?
Yeah.
I really wish I could pay taxes. But that's the idea. Portability is something that when your spouse passes, you need to get advice. You have to get advice within 9 months. I know that you're in crisis. I get that. But you have to seek some advice. Planners, lawyers, CPAs, you have to, because the portability, you have to elect to take this so that basically after my spouse passes, I get to steal their estate tax. I get to add it to mine, but I don't if I don't tell the IRS within 9 months I want to do
Oh, so that doesn't happen automatically?
It does not.
Okay.
And that's why it's important, even though you're in crisis, to come and talk to somebody, because you don't know if it applies. We just don't know. I mean, I'm going to tell you, what the rules are today will not be the rules in a year, in 2 years, in 5 years. They change too often. Just make an appointment with somebody and just talk it out.
Right. A will. So do you have one?
I do. I do. I'm actually going to be honest. I'm an attorney that has one. It's a rarity.
Right.
We were one of the worst people ever for estate planning.
Taking care of yourself.
Yes, right?
Right.
The cobbler's son, that
Right.
theory.
Right.
But again, I'm a control freak, so I've got mine. Do you have yours?
I do have mine.
Good.
No, so when was the last time that you updated yours?
I updated it about 6 months ago.
All right, very good.
Yes,
Very good.
I made a change in my ultimate executor.
There.
When do you do that, right? When do you update it? And I like to tell people, every 5 years you should look at your estate plan, whatever it is, right? At least 5 years. But births, deaths, any type of major life event.
Mm-hmm.
I can tell you my power of attorney for healthcare. Right? I have a brother who's a physician. Obviously, after my husband, makes sense.
Right.
Right? When he watches this, he's going to be upset. But my father had a health event, and I changed my power of attorney after watching how everything played out. I learned how he would react, fantastically, number one, but is it the way I would want? And that's what happens, right? You need to look at life events and see, how do they affect people? Do they rise to the occasion? Obviously, my brother did, but I then saw my sister-in-law who was who was the advocate for her mom, and I thought that was the person that fit my goals and desires more. So updating is important because when you see what happens, that's when you have to decide. Is this the right person?
Yeah, and or people, right? You can have more than one person,
Oh, yes.
right?
Yeah, you can always have more than one. Sometimes you got to be careful. You don't really want to pick two control freaks. That might not be a good plan. Or it's the little things is you want to make sure they can work together because they will have to work together.
Right.
So let's talk about the will versus the no will situation. So will, control over my own life. Love it. No will, the state that you die in decides what happens. That's called intestate succession. A will, you get to nominate that person, right? Not everybody is good at this, and that's okay. And then not everybody has to be good at it.
Right.
But you don't want a person who's not good at it handling it.
So you want to take your time, and that's one of the reasons why we talk about proactive planning. You might have thought of someone, just a quick family member, my brother, for example, might not be the best person to come in and act in that capacity, right, for me. And so...
we're talking about some people are really good at finances, other are not, right? I've got different choices for my health care and my finances. Those are two different brains, generally.
Right.
Certain people are going to be better at others.
Right.
Here's the problem, though. If you don't decide, the state decides. There is a order of priority that's listed by the state of California. That would not work in my family. I would disagree with it. Again, just because everyone's different. People have different lifestyles. People have different brains. Some people, I like to look at, when I talk to my clients, is one more arts driven, one more financial driven, one more, money burns a hole in their pocket.
Oh, yeah.
One's more too adverse to any risk.
Right.
That can't be a good thing either. So
Yeah.
you've got to remember that just because the state of California has decided what's right, it may not be right for you.
Right. And you can always change the person, right? So it's not, set in stone. You can, if you find out later that you found someone, like in your case, that you thought was a better. Representative, right? You can always change it.
Yeah, and people's life experience changes, right? Somebody who had plenty of time now got a job overseas, has, 6 kids, and there's no way I would want to put that burden on them. Those kind of things. Life events change your decision making.
Right.
So if you have a will, a probate judge may also still oversee it. It's, it depends, right? If you have a will and you have more than $166,250 in your estate or real property, and we'll talk about that if you want, then a judge is still going to oversee it, right? You still have to go to probate. But your wishes are going to be followed to the extent they legally can.
So they will essentially just have to confirm that you did put something in place.
Correct.
But you may not have to go through the entire probate process.
You will have to go through the whole process, because if it's under $166,250, then you can do something what we call a small estate affidavit. Somebody else can sign. The person that you nominate can go ahead and sign, depending, or your heirs that you've listed in your will can sign. But if you have over $166,250 and real property, because let's face it, why do we go to probate? And we're going to talk about that next. It's so somebody can sign your name. What can't you do when you're dead?
Right.
Sign your name.
Sign.
So a will and probate, the probate judge is going to nominate who can sign, is going to appoint who can sign your name. You nominate the person. The judge is going to follow that unless, if they're in prison or something, he's not going to approve that person.
Right.
But you nominate them, the judge appoints them. If you don't have a will, you're definitely going to have the judge oversee it, but the judge is just going to follow the state rules. Probably some fights are going to happen.
Certainly.
We always see that because everybody wants to be in control. So we usually see a few competing petitions for probate.
Right. So this is, again, one of the reasons why you certainly consider having a will versus not having a will, but that might not be all that you need.
No, it's not, and we will talk about some alternatives.
Right.
But why at least have a will, right? I say at a minimum have a will, because if you don't, you have no control over the distribution, right? If you think about it, my kids are still younger, but they could grow up and not be very good money managers. And that's a nice way of saying they might need somebody to control their money, right? They could make poor life choices. They might have spouses. We call them outlaws, not in-laws. They might have a spouse that we don't really want to have them controlling them. Well, you can't decide how it goes, right? So if you don't have a will, it's just going to go your heirs at law. And that's defined by either your spouse, depending on the kind of property, spouse and your kids. If you don't have kids, maybe the grandkids. Without the kids, it's the siblings. It's called the table of consanguinity. Consanguinity, if you want to Google it. So all children are created equally, regardless of their situation. And as we said,
that's typically not in someone's best interest, potentially.
Potentially,
right?
Because we have to look at who our family is with, eyes wide open. Take off the rose-colored glasses. Is a pile of money a good thing?
Right.
Sometimes it's not.
Sometimes it's not. Yeah.
Is there one child who really could benefit from the family home? Those are the things that's important. So we've got the next of kin, and that's why I said the table of consanguinity. And then, again, be mindful of the state you die in, because that's going to make a difference. Every state has their different rules. So if you have your own will, my rules control, right?
Right.
And then there's additional taxes, penalties, fees, because if you don't do the proper planning, you don't have control.
And it's a pretty simple document, isn't it?
Oh my gosh, yes.
Yeah.
Yeah, I'd hate to tell everybody, you can handwrite it. It's called a holographic will. I'd recommend you speak with counsel, or, the state of California does have a form will that you can always download. I think it's on the State Bar website.
Right.
But some office supply places have them. But you should really talk to somebody. But it is a very simple document. It's not extreme. It's not very complicated.
Right.
You can do it.
Now, advantages of creating a will.
Again, you decide. You appoint the person who's going to make your decisions. This is the person that you know is capable. And not just maybe the loudest in the room. We see that a lot, right? The loudest in the room sometimes wins.
Right.
So you get to decide. You also get to decide where it goes.
Yeah,
And
that's very important.
It is. There are, in some families, let's say Dad had a train collection, right? One child cared about that train collection.
Right.
But that train collection has a substantial value.
Right.
So do you want the train collection sold and given to the 3 kids? Or do you want the train collection to given to the 1 child that actually cares for it?
So if I don't know any difference, I was just told to make sure that I disperse everything, I probably would have just sold that and just, given everyone their portion. But that 1 child who really cared for that issue, that might not have been the best decision for them.
Exactly. And not putting it in writing, the judge doesn't have a choice, right? The law is the law is the law. So you can circumvent those rules by making decisions for yourself.
So getting to decide what is given to who, but also being able to decide when, right? And that's an extremely important decision because not everyone, is going to be potentially mature enough to receive those resources right up front, right? And so there are options that you can put into your will that can define how that's laid out as well.
Think about, you got that classic car sitting in there and you've got the 8-year-old, 9-year-old grandson who really wants it. We can't give it to him right away.
Right.
So you can decide when he turns 16, 18, 25, whatever, you can decide how and when he gets that car.
Right.
So those kind of things. You can allow assets to transfer to a trust. We're going to talk about trust, which I'm going to highly recommend. We're going to talk about trust, and this way you can have things continue. And that's what we were talking about. You can decide when they get things. We can create them. There's also a benefit of doing it for purposes of public benefit planning, so we're not going to get into that today. But there's a lot of benefits to be able to use a trust through a will.
Right.
So you may not want to get extremely detailed now, but when you die, you can have your executor deal with it. Because, again, what do you care? You're dead.
Again, one of the things that a lot of our children may not be aware of is the charities that we prefer, right? And so, again, if we don't properly document that upon our passing, we may lose that opportunity to leave a lasting legacy. So that's another good thing that a will might be good for.
Correct. Okay, so disadvantages. Again, we talked about probate court. We're gonna, again, our probate judges are wonderful, but stay out of court. Trust me.
No one wants to go to court.
Nobody wants to go to court. I mean, the lawyers make a lot of money at it, but stay out of court. Again, public record. I'm going to tell you the most shocking part of any person that starts this business is when you file a probate, how many phone calls you get from realtors.
Oh, right.
Shocking amount of phone calls from all sorts of different types of businesses, and it's amazing. Not only does usually the grieving child or spouse, because they're the petitioner, get these phone calls, the lawyers get the phone calls. There are people for their business, and it's a good business model for them, is to check the court's website and to see what's been filed.
Yeah.
So you now have just become public. All of your business, especially if you've got some difficult situations, is now going to be public.
Right. So for those of us who prefer to be a little bit more private, right, if we don't have this well-prepared, well-documented, all of a sudden, upon our passing, we have no control over it at that point, everything now becomes public.
Yes.
Right.
And with that going public is creditors. So you have to publish your death. Well, you're dead, but your executor will have to publish your death to give creditors a chance to file a claim against your estate.
Right.
So we don't really want to rely on just a will. So it's a disadvantage, and that's why we're going to talk about trust next, because that's the win. But it's better to have something rather than nothing, but you still have the disadvantages of having creditors' issues. There is no tax advantage. You have not created whatever planning you need to do to avoid some taxes, whatever it's going to look like for you. You can't have done that through the probate process.
Right.
And high administration costs and fees. That is what gets everybody.
Right.
We in the estate planning world consider probates really a windfall. Right? Yes, a trust and a full estate plan may cost some money. Nowhere near the cost of probate. It is shocking. It's a percentage of the gross estate, meaning they don't care how much mortgage is on your house. The attorney still gets a cut of the full value.
The full entire value.
Yes.
Okay.
So you got to think about that. And let's say we don't have a child or a loved one who may be the best executor, or a third party could also get the same fee. So the executor gets a fee, the attorney gets a fee, there's a probate referee who gets a fee, there's court, filing fees. I mean,
List
there's
goes
fees.
on and
There's fees
on
and fees
and
and fees. So if you really want to protect it, and let's say all you have is the family home,
Right,
where are all those fees going to be paid for?
right.
You know,
From the
you've got a good, it's a $400,000 home. You
Right.
still could have upwards of $20,000 in fees.
Yeah, and so if that's the only place that they can get the fees, then they have to
sell
sell the
them.
home.
Yeah,
And if it's another 2008, we wouldn't have wanted to do that, right?
exactly.
So you lose control, and unfortunately, the family can lose out a lot more, right?
True,
without that
especially,
proper
and
planning.
a lot of times, you're here because you either know the benefits of Southern Caregiver Resource Center, you are a caregiver yourself. There are a lot of caregivers, especially in my world that I see, who have given up their lives to come take care of their parents. So they need that family home.
Right,
They have given up their jobs. They have sold their homes to come live in their parents' home so that they didn't have to go be put in a facility. If you have to sell that home and you're in crisis, you haven't had a job for 5 years, you just lost your purpose and your parent. And now you're going to lose your home.
and potentially your home. That's
So,
right. Yeah.
there's a lot. It's important just to talk to somebody about it.
Right.
See what applies to you. Okay, so what is probate?
We mentioned it.
I make the joke. It's the lawsuit that you file against yourself after you're dead in favor of your lawyer and your creditors, right?
That's a good one.
The people that make out, the lawyer, the creditors, and it is a legal proceeding, so it's a lawsuit. So that's what I, joke about it. But it's really just the legal process by which a judge decides who can sign your name when you're dead. So if you have assets like a home, a bank account, anything that needs your signature, I'm going to accept out vehicles because the DMV has a system for that, but anything that really needs your signature, you can't do that when you're dead.
Right.
So you have to go through probate. That's, in a nutshell, I think it gives people the idea of, okay, if I need to transfer this with a signature and I'm dead, we're going to probate.
So it's supposed to be for your protection,
Yes.
right? Because now you can't speak for yourself, and there may be some assets that need to be left to someone,
Exactly.
right? And decisions that have to be made, and so essentially the courts will step in if it's not documented some other way.
Exactly.
Right.
And it's a good thing to have. I'm just saying it's expensive.
Sure.
And I think it's on here, I don't know, time consuming. Very time consuming, because I just told you there's processes. You have to get a hearing date. You have to let creditors know. You have to have creditors timed
Right.
to make claims.
Oh, yeah.
You have to do accountings. You have to
Right.
make filings.
Right.
It's going to take time.
So a lot of people getting involved in this process, right? And it may not have been necessary, right?
Yes.
So even though it's something that may be for your protection because nothing else was documented, a lot of these expenses, right, getting all of these individuals involved, that also may not have been necessary,
Exactly.
right?
So we want to avoid it. So as we kind of said, I'll skip through some of this because I always get ahead of myself in the slides, is, if you don't have a will, you'll still be probated, but it's going to be the state that decides. If you have a will, it'll still be probated over those certain values, but now you decide.
Right.
So how do we avoid it?
So some of the things that we can do is, we talked about previously, we can gift assets, right? And so we have our limits to how much we can gift, without incurring any additional tax implications, but we can certainly gift money to other people, and that reduces it from our estate. We can have joint ownership
Yep.
in items, right?
Very good option for a lot of people.
Sometimes that's a good thing, other times it's not. Again, you have to make sure that you speak to the proper counsel,
Yes.
right? Get the right information
And
about
joint-
whether or not that's a good idea.
Sorry for
No
joint
problem.
ownership has a bunch of different ways it can pass too, and different standards. So you need to make sure if it's a bank account or an investment account, like a securities account, joint ownership is a little different on those.
Right.
So you're going to just want to make sure if you do joint ownership, you know why, how, and that you didn't accidentally make a mistake in another document, because we see conflicting documents a lot when there's joint ownership.
Right. So one of the things that comes up quite a bit, actually, Kim, is people will come and will mention that they've placed their children on their home. So now their children have joint ownership on the home. And that could be,
anxiety.
okay, so it's not usually a good thing then, from your response there.
Well, you run into problems, right? You run into tax. You don't get the benefit of a step up in basis.
Right.
Let's see, mom and dad. I mean, I got people, their houses have a original purchase price of $20,000, $30,000.
Yeah, that's my parents too.
They're worth $700,000, $800,000 now.
Right.
We have, if it's in Leucadia, it's worth
Right.
$2 million.
Right,
Right? So you put your kids on there,
right.
they're only going to get a little bit of step up, and we're not going to get in all the taxes. Just know that it's not a good idea.
Right,
Just
no.
trust me on that one.
Yeah, so that you lost a great tax saving opportunity
Yes.
by making them a joint owner on that property.
And you've also now unintentionally put your children's creditors at you've risked your estate for that. I can't control. I don't think your kids are bad. I never go into saying your kids are bad, they're getting gambling debts and whatever. I can't control them getting in a car accident.
Right.
I can't control someone slipping and falling in their house. I can't control, business litigation. There are certain types of careers, doctors, real estate, lawyers, people sue people for anything these days.
Right.
So you got to be mindful. Somebody owns their own business and it's some sort of construction business, they're probably going to get sued along the way.
Yeah.
I mean, it's just common. It's just what we see as lawyers.
Right.
So you got to be mindful about putting other people on your assets because now their debts become your problem.
So now in this potentially litigious environment that find ourselves in, unfortunately, we can inadvertently,
Yes.
add more risk that we're not even aware of.
Exactly.
Just by placing someone on our joint accounts and or property.
Yeah.
Right?
So you just want to be mindful. A lot of times it makes sense, but just be mindful. Do it with your eyes wide open, hopefully with some sort of advice.
Counsel, right. IRAs, life insurance, annuities, retirement plans, all of those have beneficiary forms. And so those beneficiary forms allow us to, essentially sideskip that probate process as well, as long as it's been done properly,
Yes.
right?
Please. If there's one thing I can have you do right now, check those right now. Not right now. Finish listening to us. But after you were done, please check them. Mistakes happen.
Sure,
They do. And life happens.
right.
Right. Things happen and you're, oh my God, I don't realize I did that.
Yeah, well, I mean, we've all heard of the situations where maybe a divorce has come up, right? And so an individual passes, we come to find that the previous spouse was the beneficiary, the named beneficiary. And even if I have it in another form of document or trust or something like that, if it's the beneficiary, right, on that account, what takes precedence?
It's going to depend on the type because you've got different types of federal law, right? Any type of 401k, you've got
Right.
federal law that you have to follow.
Right.
IRAs, state law. I mean, things are going to change. Maybe that beneficiary designation will be usurped by the divorce. Maybe it won't.
Right.
And even if it is, if it's over 166,250, you
Right.
go into probate.
There's another issue right there.
So
Yeah.
you just want to always make sure that everything is updated. And so just double check. It doesn't hurt.
It's
You
a good
call them
reminder.
up. Call them up or go online even.
Yeah, it's very easy, right? Pay on death accounts or transfer on death, like bank accounts, right? Brokerage accounts, and even real estate, right? And ways that we hold title to real estate, right? Can make it simple to have assets, avoid the probate issue.
I'm a big fan of PODs and TODs, just so you know.
Sure.
Yeah, I like them a lot.
It's simple, doesn't cost us anything.
Yeah.
And we basically can get it taken care of there. And it resolves a lot of issues, right?
Yes.
So now, your favorite topic.
Yes. Trusts. We love trusts. Trusts are not as complicated as they sound. Everybody thinks they're complicated. I don't know why. Maybe because they're usually that thick.
Right, and or thicker, right?
Yeah. But they're really not if you think about what it is.
Right.
All it is think of it as a bucket. You put stuff in your bucket, right? Your trust is just a document that you put things in, right? You put your house in. You put your bank accounts in. And all that really means is I changed my last name. Kimberly McGee, comma, trustee.
There you
That's
go.
all. And I've now put things in my bucket. So the thought is, when I talked about A probate you need to do because somebody has to sign your name. All a trust really is listing out who's going to sign your name when you no longer can't.
Right.
That's it.
Right.
That's what makes the difference between a trust and a will. It defines who can sign your name without a judge having to do it.
Right.
So it's the same thing as a will where it defines how your assets will go. But now, since somebody's already defined to sign your name, you don't need a judge to appoint that person.
Got it.
You don't need to have the world know about what's in your estate plan because I've already said my successor trustee can sign my name if I no longer can. So while I'm alive and well, my trust is managed by me. I am the creator of it. I am the manager or the trustee. When in doubt, blame a lawyer. Don't get hung up on the words. Just realize that there's a manager, and that's the trustee. And I'm also the person that benefits. I'm the beneficiary.
So it's your instruction manual,
It
essentially.
is.
Right?
It is. And so let's say I become incapacitated. Well, I've decided who will be my successor trustee or my backup manager.
Right.
That's it. But it's still my money. I just have somebody else managing it.
But you're the first person that manages
Yeah.
it.
I
Right?
start managing it until I lose
Right.
till I lose capacity in some way, shape, or form. Either I'm unconscious in a hospital
Right.
or I have some cognitive impairment problems.
Right. And inside of your trust, you get to actually highlight what that would
Yes.
look like even.
Yes, if I want to rent a castle in Scotland for the rest of my life, whether I am dinghy as a bat or not, I can put that in my trust. And my backup manager has to follow it.
So now I know what's in your trust.
So some of the advantages, right? You're going to draft documents with your specific instructions. Again,
Your manual.
your manual. You know, there are things that people want. There are things that they don't. I have a lot of clients who have decided that when they lose cognition and they don't really have a high quality of life, that they don't want very much spent on them. They don't want all like extra comfort and enjoyment. They want the basics. You know, so they've decided that. They've decided how and when my money's going to be spent. That's a
That's a big deal.
Control. You're most likely going to avoid probate because you have decided. So as long as you put stuff in the trust, then you're going to avoid it.
And again, the will couldn't accomplish that for you.
No, you have, because again, your will nominates somebody to sign your name.
Right.
A judge appoints somebody to sign your name.
Right.
Your trust, you've decided who can sign your name, and it's legally binding.
The next one's really important for me, maintaining privacy.
Yeah.
Yeah, I prefer not to let everyone know, essentially, what I've done, I mean, good or bad, what I've done to make sure that my family is taken care of or what my family has. It's no one's business to know what charities I want to give to or how much I want to give to them, right? And so it's one of the good things about a trust is it helps us maintain that privacy.
And just even protection, right? What happens when somebody dies? You're grieving. You
Right.
are vulnerable. Like
Right.
when you are going through grief, that is probably the most vulnerable time you're going to be.
Absolutely.
And when you don't have that privacy and you've gone through a public proceeding, there are bad people in this world. There just are.
Unfortunately.
And they can prey on your vulnerability and they can run into you at the grocery store. They can find you in the coffee shop. These are real stories of people who have been taken advantage of because of their vulnerability because their life was not kept private.
Right. So it allows you to, have, again, a simple process for leaving your assets, for dictating who's going to be in charge, and for making sure that everything gets handled with the least amount of expenses.
Correct. Yep. Yeah. You want to, really, the creditors, no beneficiary can receive funds over a creditor. That's just the case. But the way the law is set out, they're going to have a whole lot less time and notice to file anything if you go through a trust. So there's some positives for you. But you really, you're going to be able to control it. Trusts seem complicated, but they really are simple. They simplify the whole process.
Yeah. I thought they were complicated before I started helping people with them as well, and realizing that, ultimately when you do get the opportunity to write your own manual,
Yep.
write your own story, right, that's much better than the thought of having someone else do it for you.
Exactly.
Right? Types of trusts. So we have a testamentary trust. So testamentary trust happens when you don't necessarily have had or have taken the opportunity to do all this while you're living.
That's what we were talking about, is that a will could create a trust. So you could create a trust through the probate process.
Right. A revocable living trust, and we'll touch on that in just a minute. An irrevocable trust, and then an irrevocable life insurance trust. And we'll touch on those in just a minute here.
So as I said, the testamentary trust, that's the one that's created through your will, right? It becomes effective after you've died. So let's say, I have clients, I get it. They're not comfortable putting their assets in a trust. I think they just don't believe me that they're still in charge of them. I don't know. And it's okay. You make your own decisions. The idea is, though, let's say you still need to protect that special needs child, or the child who's vulnerable to being taken advantage of, or minors. You can then create a trust through the probate process. So that's an option as well. You don't have to do it while you're living.
Right. And a lot of people actually will add this as an option in their own trusts.
Yes.
Right, so that they can create a trust for their children so that the monies don't actually go to the children immediately, but maybe remain protected in their own trusts, correct?
Correct.
Right.
Yes. You can always create a continuing trust in your own trust.
A revocable living trust. So again, while you're living, and this is, ultimately why we're here, right?
Yes.
Talking to people, making sure that everyone has an opportunity to make their own decisions about the things that they want most, and the things that they want to see happen upon their passing, who they want their assets to go to, what direction they want taken, all of those things. You get to decide, and you get the opportunity, have all of that remain private for you if you do that through a revocable living trust.
Correct. Now, an irrevocable trust. These are used in very specific circumstances. So not very many people have them, but the people that need them should have them, right? Unlike the revocable living trust, which is amendable, revocable, you have an irrevocable, which cannot be amended. It cannot be revoked. Well, limited exceptions. There's now something. There's an exception to every rule at this point. But for the most part, it can't be changed or revoked, or at least the major portions of it cannot be changed or revoked.
And then we have the irrevocable life insurance trust. And so essentially it is an irrevocable trust that's used for a specific purpose of maybe taking some assets outside of your trust. And as the title indicates, there's some life insurance that comes into play that can help create some distinct tax benefits. Mm-hmm. And so this is something, again, for very specialized cases, but there are options.
And when it comes to the life insurance trust, it's important to look at when the estate tax goes down. I believe it will. I mean, again, I don't have a crystal ball, but my belief is it's going to be decreased. It may be a really good option for some sort of wealth transfer without taxable liability. So I feel that, they may have become less popular in the $11 million range estate planning, but I feel like they're going to come back into really common parts of everyone's basic estate plan.
Seems like that's the way we're going.
Mm-hmm.
So in conclusion, again, estate planning, it can seem like it can be complicated, but working with a professional who understands this, right, who's been doing it for a long time, specializes in it, of course, is one way to make sure that you at least get your affairs organized, right, put your manual together, and allows you to have, be the ultimate decision maker in your life, right? So please make sure that you get your documents drafted by some professional at your earliest convenience.
Please, finding the right attorney. I'm a big believer in jack of all trades, master of none. I really believe that.
Yeah.
There's a time and a place for a jack of all trades. Attorneys, just like physicians now, there's so many laws. There's so much to know that if you really go to somebody who does everything, general practitioners are not common anymore. I don't even know if I know one. But try to avoid going to somebody who's not an actual estate planner, an elder law attorney. You want to have a communication and trust, right? We are service providers. Mm-hmm. We are professionals. We are service providers.
Right.
If you don't trust us, and if you can't communicate with us, don't use us.
Right.
Find somebody who you do trust.
Right.
Find somebody who you can communicate with. I get it. I'm not for everybody, and that's okay.
Right.
Call me. I got lots of referrals,
Yeah.
different personality types.
Yeah.
You have to be there. I want somebody who is comfortable being questioned, who's comfortable being challenged, right? If you question any professional in your life, any professional, and they are offended, run away. Run as fast as you can, right? Because they don't know the answer.
Right.
Or they're not, maybe there's something more behind it. So run away, question them, challenge them. If they have the answers, they're the right person for you.
Right.
You know, do they have a succession plan? That's important. So if I get hit by the bus,
Right.
what's going to happen? Well, I have one. So ask what happens if you die, because an estate planning attorney, an elder law attorney, that's going to be in your life forever. I mean, we at my office are up to third generations of people.
Oh, that's great.
I love it. I love like, your grandma had this, or, it's nice that we have that bond.
Right.
Estate planning, when creating a good plan, ask if they handle administration. And the reason why is because do they know the effect of their plan? Mm-hmm. Do they know what's going to happen if they put something in the document? So that's always good to know. And I hate to say, you want to have a fair price, but if it's too cheap, you get what you pay for.
Yeah, well, no, I tell people, right, you can't go back and fix it after it's done, right?
Well, we do administration, and I'm going to tell you, we make a lot of money off of those cheap trusts. There's a lot of issues.
And finding the right advisor, right? You want to work with someone who is a fiduciary, right? Puts your interests first. And so there's a lot of people out there that we're not certain whether or not they would be willing to put themselves legally liable for the advice that they give. So it's a good idea to ask if they are a fiduciary. Offering a complimentary consultation. Like if I can't determine, right, what personality type would be good for you, right, would be good for us, right, by, without at least having a first initial consultation. And so it always works.
Yeah,
right?
Your financial advisor should be with you your whole life and may also participate in your children's lives.
That's right.
So, you want to make sure that that's the person you like to talk to.
Yeah, and it's very important. Again, if you don't feel comfortable speaking to this person, ultimately, you're not going to share enough for them to really be effective for you. So, one that has a good reputation, and as you mentioned, you're right, it's not cheap, right, when we're considering making decisions that will last your lifetime, that can help you, right, have a comfortable lifetime and lifestyle, and will make sure that you don't have to worry about, right, do you have to go back and rectify issues and things like that. So help you sleep well at night.
Exactly. One of the best things that my clients have said is, wow, I have this weight lifted off my shoulders, and you don't know you have the weight till it's gone. Right?
Right.
Because you care about your loved ones.
Right.
And doing this for them, it's a gift.
Yeah.
So I always say, make that gift to your loved ones. Don't leave them with that mess.
Right. So we say more important than leaving an inheritance is leaving a legacy.
Yes.
Right? And so part of this, being here with you, sharing these things with you, is a way for us to help in this legacy process. So thank you for being here with us today.
Thank you. So we're going to stick around for your questions. And so we really enjoyed our time. We hope you enjoyed having us as well.
Thank you.
Thank you so much, Kim and Daniel. That was so informative. I was taking a lot of notes, and I really liked your presentation and your take on things. I know that financial planning seems like such a daunting task, and especially, year-end estate law and taxes and, all of those things that we're not familiar with. It just seems very complicated, but you made it, if anything, you allowed people to start thinking about the process. And I know that as a former caregiver, that's one of the things that maybe it's not on the forefront of your mind, thinking about these type of questions. So the fact that we're all here taking notes, listening to both of you, it is really important, so that as we do move ahead in our caregiving situation and plan ahead, we can get some of these questions answered. So again, thank you so much. I do have a couple of questions, and so I just wanted to maybe start off with some that we have been receiving. The first one is, my mother has dementia, and she did not fulfill her document when she was healthy. Now what? So, I know both of you have worked with caregivers who are caring for someone that maybe has dementia. So, I don't know if either of you, which of you wants to answer this question?
Well, I'll take the first stab. So the issue we run into is a diagnosis alone is insufficient to deem somebody incapacitated in California, and that's in the probate code. So you know your mom at 100%. The question under the law, though, is does she understand the nature and consequences of her decision? So I wouldn't necessarily say just because there's a diagnosis, it means that you're limited in the planning options that you have. If somebody does not comprehend the nature and consequences of their decision, does not understand what a power of attorney is, does not understand what a will is, that's when the really only option is a conservatorship. We do call that the nuclear option in our office because, we talked a lot about fees. It's a very expensive, it's a very burdensome, it's a very emotionally draining procedure because you now have a court involved in your very intimate family lives. But unfortunately, that may be the only option. So it's important to kind of get professionals who have the knowledge of what capacity truly means involved in the decision. There are plenty of counsel in, Southern California, all throughout California, who understand legal capacity, which, because of the way legal capacity is defined, it may be different than what the physician has defined as well. So balancing your checkbook might not be the same as deciding who can balance your checkbook.
And taking this
Thank you,
opportunity really
Kim.
not just to consider the legal aspects of it, but also the financial aspects. Obviously, when we reach this stage now, we see that maybe inconsistencies have been coming around. I'll get this question a lot, where people say, "Well, I have noticed certain things coming," and so you'll want to start thinking back. When did you start to notice these things? And are there any inconsistencies that you might find, maybe even in their accounts, that you will have to go back and review and things like that? But certainly, looking at not just how to help her manage her affairs on the legal aspects and how to make sure that you have the authority to do that, but you want to start making sure that you have documented everything and have gone through what issues might have been apparent that you might not have seen over the past year or two.
Thank you. Thank you both for taking that question. The other question that we have here is, you talked a lot about legacy and really thinking about your assets, especially when it comes to your family and how do you transfer that. But I guess it really is, how do you take an inventory of what is important and what might be maybe a second or third tier, because what happens to all those assets when you die, when you are no longer there? How do you assess that? How do I go about, okay, this is really important, I need to talk to a financial planner, this is maybe not something that is that important? And I'm not talking about shoes and purses, I'm talking about assets.
Yeah. So one of the things that we attempt to do with our families is really make sure that they document, like you're saying, not just the financial assets in their accounts, and of course they want to have a very well organized financial life, but also the things that would be more of a legacy, that they're leaving to their families, their stories, their memories, things that we know need to get passed down from generation to generation, things that we really want to get taught, right, to the next generation. And sometimes, unfortunately, we're not seeing that happen now. And so working in concert with a really good estate planner, many times, aside from just making sure that your accounts are titled properly, it's making sure that you really provide a story of what you want to see passed down to the next generation. And a lot of times that there's a letter even that's written in sometimes left in a binder like an estate plan. I've seen that happen a lot of times, where we have the privilege and opportunity to speak to the family in advance of their passing on any of their wealth, and sharing with them not just how they pass on their physical and financial wealth, but how they truly do pass on the legacy of their giving, for example, to an organization like SCRC, how they do that, why they do that, and setting up, again, that generation of givers and creating a true legacy from what our perspective is.
I like the way you put it, Daniel, that generation of givers. I know that I try to do that with instill that in my children and in their little, but even the idea of donating, giving, finding a one way to help out their community or members of their community, and that's something that we could all cultivate through all of our lives. The next question I have here is, how do I protect my assets from rapidly increasing healthcare and long-term care costs? That is so true. I know that when I was a caregiver, and even in talking to other fellow caregivers when I'm doing presentations, it's always the question of, gosh, long-term care is so expensive and healthcare costs keep going up. If I plan now for that, how is that going to be 30 years from now when I need that kind of healthcare? It's so expensive. How do I plan for that?
Kim, would you like to take the first stab at that?
Well, that the answer is, I don't know. Now, the truth is there's multiple vehicles by which to do it. One of the things that if you're young enough and healthy enough to explore long-term care insurance, right? That is probably the best way to manage it. Make sure it comes with an inflation rate, so it follows through with the changes. Unfortunately, due to the costs, sometimes that's just not an option. So we also want to kind of look at alternative funding sources, right? Self-funding your long-term care and really being mindful about high income source assets, those kind of things in the long run. If you're already at that stage and it's too late to pre-plan, then, meaning you planning through 20 years in the history. But if you can do something like speak with a qualified elder law attorney, talk about what Medi-Cal options are, veterans benefits, some of the greatest benefits there are for keeping somebody at home and providing great and terrific long-term care is if you've got a serviceman or woman who served one time, one day, that's all, of active duty during a wartime period. So you need 90 days total, but only one of those days had to be during a wartime period. You'd be service eligible for veterans benefits. So you should always explore the different potentials that are out there. Some people don't think Medi-Cal is an option. They think they have too much, and that's usually not true because they have created programs to protect spouses. And so that you can have a lot more assets than you thought you could. Your home is always exempt. Your IRAs are exempt. There's a lot of ways to reach out and kind of supplement long-term care that people don't realize are out there.
Yeah, that's a very good point, Kim. As a matter of fact, many times we'll find that people are concerned that they have too much in assets to qualify for certain benefits. And the reality is, it's just a matter of, well, what are those assets? Are any of them exempt? Are any of them, those that can easily be shifted and or transferred or other things? And finding a qualified elder care attorney can come up with some creative strategies to help make sure that your assets are protected, that you have everything that you need for your lifetime, and then what remains is protected for your children moving forward. But the key to that is that you have everything that you need over your lifetime. A lot of times people will do some creative thinking on their own without seeking good guidance, and many times that will actually hurt or hinder their own retirement needs, right? So remember, we are going to be living a lot longer nowadays, and so maybe not the healthiest, but a lot longer. And so we need to make sure that our assets do support us throughout our lifetime. So like Kim had mentioned, there are traditional strategies like long-term care. A good qualified insurance planner or financial advisor can help you walk through those strategies, some of which you pay for on an ongoing basis. Others maybe you don't have to pay for on an ongoing basis. It's just a matter of maybe considering what other types of assets you have that could be better used or shifted into some type of long-term care, support or supplement for you in the future. And so, yeah, there are a lot of different ways that we'll speak to our families about helping to protect against, having to spend down assets needlessly. And it's just a matter of looking at all the different assets, again, prioritizing what's important for them now in their retirement, and then what could potentially be used to help support that need should it arise in the future. Good question.
I'm
And
so
I
glad
guess,
that you said that.
oh,
Go
sorry.
ahead, Kim.
I just wanted to throw on there, in the event that somebody does receive Medi-Cal benefits, you'll get your letter saying that there's an estate recovery. That is where the trust information is so important. Medi-Cal can only recover from your probate estate. We just walked through all the reasons we hate probate. But the most important reason to have a trust, if you do have a loved one or if you are on public benefits, is you could prevent it and preserve it for your legacy, for your children and your heirs. So it's very important to explore that. Don't just accept the benefit without understanding the full consequences.
Right.
Great. I do have one question here, and it's very specific. Someone is asking about their mother, and they're saying that if mom's assets are less than 100,000, is all she need in terms of a form, the California state form, the small estate affidavit?
Yes. So in theory, without knowing more facts, as long as the estate is below 166,250, a small estate affidavit will be sufficient to collect the assets. Keep in mind though, all of the beneficiaries or heirs have to sign it unless there's a will or some other document that defines another procedure. So just make sure you're following the law. But yes, 166,250 is our magic number for probate.
And I have another question. Oh, sorry. Go ahead, Daniel.
No, no, no. No, I was also saying, and it's also important to identify how those assets are held, because as Kim mentioned earlier, if they're inside of a retirement plan or a qualified plan, right, that might have some additional protections.
So, which goes along with my next question here that it says, can I pass assets on without any court administration?
So yes, that was what we were discussing when it comes, if it's in anything in a trust, unless there's a fight, we'll go without administration, without court procedure. There will be an internal trust administration. But we were joking about how much I like PODs and TODs, and so does Daniel. Payable on death, transfer on death, beneficiary designations, those types of things will pass automatically upon someone's death. So it's a good thing. There's also, joint tenancy deeds, which you got to be mindful. I kind of warned there's some positives and negatives of joint ownership, and you have to be very careful with that. But there are different ways. So, but POD, TOD, and beneficiary designations, I think, are probably the safest and most easiest way to transfer assets.
So to be clear, life insurance policies, retirement plans, again, 401ks, IRAs, 403bs, 457s, all of these types of accounts that have beneficiary form designations, you get to decide who those assets would actually ultimately transfer. And it's a very simple process that wouldn't require, unless there's any other outside reason, but that wouldn't require those assets to go through probate.
So, what I think I would definitely want our listeners and our viewers to take from this discussion today is that you want to make sure that you have control over this financial future, your assets, how things are going to be transferred. We might have some ideas ideally in our mind, and that's the only place where they reside. And then nobody knows, and you die. And then what are we going to do with this? And, a lot of us experience that through our families because of lack of this awareness, right, of financial education. I think maybe our generation is becoming a little bit more savvy in this regard, wanting to figure out am I going to take care of not only my assets, but mom's assets or whoever it is that you're caring for. It is so
Mhm.
important to be able to have this control. And I know, Kim, we kept talking about being a control freak. And it's interesting because I don't consider necessarily myself a control freak, but then when I think about it in those terms, I do want to make sure that I'm the one that's in control of my assets.
Yep.
And so this is so important. And I have one last question here that just came in, and they want to know how much does a this type of a consultation cost? Where does one go to? I know that with Southern Caregiver Resource Center, working with people like you, Kim, and Daniel, we're very fortunate that you are very much supporters. You sit on our board of directors and have do this kind of work. We also, just for our listeners so that they know, we do have a program where we pay for the initial consultation so that you don't have to, so that you can get all of these questions answered for free. So make sure, of course, that you connect with us so that we can connect you to the wonderful people out in our community and have all this information.
Yeah.
Do you have an idea, more or less, how much people can expect to pay?
Well, for attorneys, there are some attorneys that do free consults, and there are attorneys that don't. I don't do free consults, but I do them for certain charities, and Southern Caregiver is one of them. So if you tell my receptionist, that's how you get into me. But for a free, but attorneys can range from a free consult to like $300, $400 an hour. I will let you know though, an attorney that charges for a consult, the reason they charge is because you're being provided legal advice. So it's different than a free consult, which at an attorney's office, which may just be trying to sell you on services. So it kind of depends, unlike a financial planner, which they're going to provide you with real information usually in their free consult. Attorneys tend to do it a little different. Either they're providing advice and charging for it, or they're just kind of giving you a bunch of options that you don't in the long run.
Yeah, so I think it's very similar with a financial planner or investment advisor. You should expect that their first consultation should be complimentary. I mean, they need to know, you need to know, first of all, if their personality is the right for you, if they seem to be competent at what they do, if you feel that you can trust them, because again, you're going to be sharing, your very, very personal, private financial information, and this is someone that you hopefully will have coming alongside you, partnering with you for the rest of your life. And so you have to be very comfortable with that relationship. And so they should be willing to give you that time at no cost to you. And so I know that that's what we do. And so I think that it's only fair that that's what you should anticipate. And even if you came along with them offering you something like a retirement plan, right? It's and I'm of the philosophy, just like an estate plan, everyone should have some kind of a roadmap for their financial life. And so that first consultation would be a great way to identify if that's something that would be beneficial for you as well.
Wonderful. Thank you. I do have one more that just came in. I think we do have a couple of minutes. So I just want to have one last question. And this is kind of, I was reading this and it made me laugh a little bit because can someone take out an insurance policy and designate someone, for example, a charity that is not the spouse?
Yeah. So Kim, is it okay if I take this one?
Yes.
I know how much you like control. So yeah. So it's actually a wonderful opportunity to be able to designate who you'd like to designate. This is your life, and you have options on doing that. Now, depending on whether or not the policy was already in force or not, there could be some additional steps that you have to take. But you can certainly choose to designate a wonderful charity like SCRC in your life insurance policy. And you don't have to do all or nothing, right? I know a lot of people are concerned about, well, I want my children to get something. Well, that's one of the greatest benefits of the life insurance option is that you can designate a portion to your favorite charities and still leave, those tax-free assets to your family as well.
Well, thank you. Thank you both. I really appreciate you taking the time. I know you're very busy, and especially during this time of year. But I just want to let our audience know that this is, these are the types of programs that we offer to you because we understand that as caregivers, or if you know someone who's a caregiver, these might be difficult conversations or that you might not be having, or that you don't even know where to begin having them. So this is a great start. Make sure you reach out to us for any assistance. We're here to help you. Don't have to do caregiving alone. Our website is www.scrc.care. Our phone number is 1-800-827-1008 or 858-268-4432. I want to say again, thank you so much to Kim and Daniel for being here with us, and to all of you who are listening and watching. Thank you so much, and make sure you stay connected with us, and we'll see you next time.
Thank you.